Gentlemen, I'm Nicholas Martin from AICS, which is Adult Child Health and Environmental Support. And I'm with Stephen Thomas, who is very famous for his action in relation to a judicial review against Cheltenham Borough Council some years ago. And we're discussing a very interesting case. I wonder whether you just wanted to outline, Stephen, the first part, and then we can go on to the second part.
Yeah, well, this is in relation now to where they want to reposition the mast, and it's in relation to another dodgy decision made by Cheltenham Borough Council in relation to tree works in a conservation area. So the applicant Vodafone um, wanted to lop a number of trees near to an existing telecommunications mast on the corner of Lansdowne and Hatherley Road. Um, that application has to go through a formal statutory Section 211 notification and assessment by Cheltenham Borough Council. So the applicant makes a formal notification. Cheltenham Borough Council has 6 weeks to assess that notification in relation to see whether a tree preservation order is required for those trees because it's in a conservation area. So Cheltenham Borough Council, what they do best, they determined that application within 7 days instead of the statutory 6 weeks, thus cutting off any possibility of people making representations, people like myself or neighbours. That 6 week period is meant to allow the tree officer to make an assessment of those trees to determine whether a tree preservation order is required.
And I
So
understand that's under their own procedures, isn't it? Their
that's
own.
that's under their very own procedure on Cheltenham Borough Council's website. It specifically says that trees in a conservation area have to go there has to be a formal notification so that a tree officer can assess whether a tree preservation order is required.
Right. And you submitted a freedom of information request subsequently, and they replied there was no tree officer's report. Is that right?
That's correct, Nicholas. Yes. So I did a freedom of information request to see that tree officer's report, and they came back saying that no such report exists.
I understand. And then in addition to that, you've inspected the trees, and there are animals nesting in the trees, which is
Yes, there are. Yeah, so I went along and took some photos, and there's nests high above. I'm not sure what they relate to, whether they're active or whether they're dormant. Nevertheless, this is something that the council should have assessed. This is what the whole 6 week period was for. So it now makes it illegal to remove those trees under Section 1 of the Wildlife and Countryside Act 1981 and also Regulation 43 of the Conservation of Habitats and Species Regulations 2017. So both of those relate to wild birds and bats.
And that's the first part of what we're discussing. And the monitoring officer, who is an officer in councils who ensures that procedures are being followed correctly, needs to be informed of this. And the external auditor for Cheltenham Borough Council needs to be informed again, because this is a potential breach of procedures and potentially a breach of the law, isn't it? Because the Wildlife and Countryside Act 1981 is very clear on the protection of animals in the area that you're talking about.
That's correct, Nicholas. And it's actually a criminal offence to remove those nests, and it's punishable by up to 2 years in prison and unlimited fines. So that could be a huge financial situation for Cheltenham Borough Council.
Right. And the Section 151 officer is a person in the councils who makes sure that everything is correct financially. So he would need to be informed as well, wouldn't he, under this situation?
Yes, yes, they would be.
Yeah,
It's not just a breach of their own procedure; it's potentially um, making them criminally liable.
I understand. And then the second part of this very interesting case is that this seems to have been a request from Vodafone, yet there's no planning application for a mast upgrade or a new mast. And there are also no details of the exclusion zone made public. Now, that would be very necessary because the UK Health Security Agency said that people with pacemakers or metal implants, that type of thing, must be aware of exclusion zones because they shouldn't go into the exclusion zones because of potential interference with their pacemakers and the like. Now, you say no exclusion zones are available for this upgrade in the apparatus, and people are living very close to the potential new mast or potentially upgraded mast. Is that correct?
That's correct. So, just take you back to the first thing you said. There was no mast upgrade application submitted with this tree approval works, and there were no details of the occupational exclusion zone. So basically, it sounds like to me that the whole mast upgrade has already been predetermined because why would you permit trees to be altered or lopped if you haven't, first of all, given the green light for the mast upgrade?
Which again is a breach of procedure, potential breach of procedure. And the last point, which is extremely important in this particular second half, is the ICNIRP guidance does not cover people with pacemakers and metal implants and the like. And we know that insurance companies will not underwrite the risk from EMF health claims for EMF health claims. So it's presumably incumbent of the council to consider their risk assessments in relation to all of this, because the risk is that people find out they're not covered under ICNIRP and then bring a claim against Cheltenham Borough Council, and there's no insurance cover for the council, which is a potential unlimited liability financial risk to the council. And what are your views on that, Stephen?
Yeah, this is where we get them. So every person that's listening to this up and down the country, um, make your councils aware and make the external auditor of your council aware about the fact that ICNIRP does not cover certain demographics, namely people with metal implants, medical implants, AIMDs, etc. They're outside the scope of ICNIRP. So, as you rightly said, a proper assessment has to be done, and we know that that there are no such assessments. They get ignored. Councils just blindly accept an ICNIRP certificate, um, which first and foremost isn't complete unless those exclusion zones are provided. And then secondly, it doesn't mitigate the people in the area who might be living close by who have such devices. And that falls squarely on the council to make that risk reconciliation. And the external auditor, needs to be made aware that there potentially is a huge financial liability that could arise in the future for councils if this isn't properly taken into account.
Absolutely. Many thanks for summarizing that. And presumably, the Section 151 officer who looks at financial aspects needs to be informed as well.
Yes,
And because all councils are under potential unlimited liability in this respect.
and
Yeah.
and those masters, you're well aware, aren't insured. They're uninsurable.
Yeah.
So they're putting this dangerous technology up everywhere. There's no clarification about the power output, the ICNIRP exclusion zones, an assessment of vulnerable residents who are living nearby. It's a perfect storm for, serious, like liability for the council, and the Section 1.5 officer